Justice delayed is not justice denied, it is justice destroyed. The High Court's ability, therefore, to stay an executive action at the very first hearing is often the only real access the citizen ever experiences. My esteemed colleagues from the Supreme Court of India, Justice Dipankar Datto, Justice Prasanna, Justice Atul Chandurkar, Justice Sri Chandrasekhar, Honorable the Chief Justice of Bombay High Court. Among us are the most distinguished, very respected to me personally, the eminent jurists and former Supreme Court judges, Honorable Mrs. Justice Sujata Manohar, Honorable Mr. Justice Varyava, Honorable Mr. Justice Sri Krishna, and Honorable Mr. Justice Gokhale. We also have among us some of the very former, very distinguished, eminent former Chief Justices of the High Courts. My friend, my guide, my mentor, and my Chief Justice, Justice Wazif Dar. My friend Justice Amjad Saeed, who adorned the Chief Justices of the Himachal Pradesh High Court. Also we have among us various very distinguished former judges of the Bombay High Court. Dear and distinguished judges of the Bombay High Court, learned Advocate General Maharashtra, learned Judicial Solicitor General of India, Mr. Nitin Thakkar, Senior Advocate and President of the Bombay Bar Association, Sri Nosad Engineer, Secretary, Bombay Bar Association, office bearers, distinguished members of the Bombay Bar Association and other associated platforms of the practicing advocates in Mumbai, eminent senior advocates coming from the Supreme Court Bar and also from the Bombay High Court Bar Association who are present on this event, members of the bar, distinguished members of the judiciary, distinguished academicians, very respectable family members of the late Sri Fali Nariman, my dear students, friends from media, ladies and gentlemen, a very good morning to all of you. It is my proud privilege and profound pleasure to deliver this memorial lecture in honor of Sri Fali Sahib Nariman, whose life and career unfolded as a living chronicle of the Indian Constitution. His practice began in 1950, the very year the Constitution of India came into force. As the nation took her first steps as a constitutional democracy, a young Fali stepped into the legal profession, ready to dedicate his life to law. In the early years of his practice, as all of you know better than me, the Constitution was still finding its voice. Landmark cases began to shape the meaning of fundamental rights, and Faliji was there absorbing and contributing to the evolving jurisprudence. He witnessed firsthand the Supreme Court's early assertions that the right of the individuals must stand firm against the power of the state, principles he would champion throughout his career. As the decades unfolded, so did Faliji's influence. He understood that the Constitution was not a static document bound by the ink of its framers, but a living charter, a moral compass that had to be defended, interpreted, and at times courageously, with courage invoked against the current of the power. The turbulent 1970s brought the nation to a constitutional crossroads. The Declaration of Emergency in 1975 tested the very soul of our democracy. During this period, Faliji's unwavering commitment to constitutional morality shone through. He resigned, as you know, as Additional Solicitor General of India in protest, a gesture that spoke louder than any legal argument ever could. In the post-emergency era, as the Supreme Court reaffirmed the inviolability of basic constitutional principles, Faliji emerged as one of the most authoritative voices of constitutionalism. His contribution to the basic structure doctrine in Keswanand Bharti, where he assisted the great Nani Palkiwala, remains the bedrock of our democracy, ensuring that the soul of the Constitution remains beyond reproach. Fali's advocacy in TMA Pai Foundation redefined the landscape of minority rights, delicately balancing the autonomy of private institutions with the overarching need for educational excellence. Whether it was helping restore constitutional order during the Arunachal Pradesh crisis by clarifying the limits of a governor's discretion in Nabam Arabia, or ensuring the rights of the marginalized in the Narmada rehabilitation case, Faliji's voice was never shrill. It was the voice of a man who knew that truth, when spoken clearly, needs no embellishment. His arguments were not just about legal interpretations. They were about the very ethos of justice, liberty, and fairness that the Constitution promised to every Indian citizen. From 1950 to his final years, Faliji's life was a mirror of the Constitution's own journey, tested, tempered, and ultimately triumphed in its ideals. In his autobiography, he wrote with characteristic humility that, and I quote, "A foreigner in Delhi has to establish himself both in integrity and ability. Only then will the Supreme Court bar accept them as one of their own." Unquote. It is safe to say that he passed that test with distinction, becoming in time a valiant custodian of the Constitution and all that it stands for. Through the 1980s and 90s and into the new millennium, Faliji continued to guide the nation's legal discourse, whether it was in moments of constitutional crisis or in the defense of fundamental freedoms. Faliji's voice carried the weight of both scholarly and with moral clarity. By the time India entered its 7 decades of constitutional democracy, Fali Nariman had become more than a jurist. He was a custodian of the constitutional spirit. He had lived through its testing moments, defended its core principles, and inspired generations of lawyers. On a personal note, I vividly recollect when I used to virtually on every day in the corridors of the Supreme Court from 2000 till I was elevated in the first week of January 2004, I used to see a roaring voice of Fali Nariman inside and outside in the corridors of the Supreme Court, on a few occasions supporting us and on some occasions opposing also. I had also the distinction of being illuminately guided by the wisdom of Fali after my elevation in 2019, Supreme Court 2019, when the age was not on his side, but his voice was equally roaring, and he would argue the case with the same effectiveness as I saw somewhere in 2000 or 2001, 2, 3. This brings us quite naturally from the man to the mechanism he is so often utilized, namely the role of the high courts and the wide discretionary powers that they wield under Article 226. That is the subject I have been assigned by the organizers to speak today. Faliji knew that for the Constitution to be a living reality, the high courts had to be more than just appellate courts. They should not remain only the revisional or appellate outposts. Rather, they had to be vibrant, accessible centers of constitutional remedy. It is here in the expansive corridors of Article 226 that the legacy of his advocacy meets the practical reality of justice for the common man. It's important, firstly, to gauge at the larger historical landscape that birthed our constitutional architecture. The saga of India's constitutional journey cannot be understood without recalling the long shadows cast by colonial rule. For nearly 2 centuries, our people lived under laws that were often instruments of control rather than guardians of freedom. Civil liberties were not merely neglected, they were deliberately denied. The voice of the Indian citizens was muted by ordinances, censorship, preventive detention, and laws that prioritize imperial convenience over human dignity. It was in the crucible of this experience that the framers of our Constitution forged the scaffolding of freedom. They had witnessed firsthand how unchecked authorities corrodes the soul of a nation. The suppression of liberties through colonial legislation left an indelible lesson, namely, freedom without the means to enforce it is fragile, and rights without remedies are hollow. Thus, for free India, they resolved that never again would the citizens be left defenseless against the state. It is in this historical context that Article 226 was conceived, a luminous testament to the framers' commitment to liberty and justice. To understand Article 226 is to understand that the Indian Constitution does not merely distribute power, it also distributes the remedy for the misuse for the Constitution through Article 32, it is that serve as ubiquitous pulse. There is a subtle yet profound distinction that makes the High Court the true first constitutional court for the citizen. While Article 32 is a fundamental right in itself, it is essentially a sort of specialist armed with a scalpel tasked with the protection of Part 3 rights under our Constitution. Article 226, by contrast, is a journalist with the power of a titan. The inclusion of the phrase, and I put it, for any other purpose, in the text of Article 226 was a deliberate masterstroke by the framers. It ensures that the High Court's reach is not confined to the rarefied air of fundamental rights, but it extends to the correction of any legal injury, the enforcement of statutory duties, and the containment of administrative caprice. As Fali often reminded us, the High Courts are not mere stepping stones to the Supreme Court. They are robust, independent constitutional courts in their own right. The decision in Bandhwa Mukti Morcha first paved the way for this line of thought when Justice Bhagwati made an observation that High Courts are called upon to enforce not only fundamental rights but also ordinary legal rights, that is, the rights created by statute for the protection of the poor, the vulnerable, the disadvantaged. These rights, Justice Bhagwati remarked and reminded us, need to be enforced as urgently, vigorously as fundamental rights. This status was then cemented in the landmark ruling of L. Chandra Kumar, where the Supreme Court declared that the power of judicial review under Article 226 is an unalterable part of the basic structure doctrine. This means that the High Court is the primary sentinel guarding the doorsteps of the ordinary citizen, ensuring that the rule of law is not a distant Delhi-centric concept, but a localized, breathing reality. The sheer breadth of this power is best seen in how the High Courts handle the doctrine of alternative remedy. While the law generally expects a litigant to exhaust other avenues, the High Court's discretion is not a tether, but a safety valve through the whirlpool exception articulated in Whirlpool Corporation case relating to trademarks. The court asserted that it will not remain a silent spectator when natural justice is violated or when an authority acts without a shred of jurisdiction. In such moments, the High Court does not just interpret the law, it rescues it. This extraordinary jurisdiction is precisely what makes the High Courts the sentinel of qui vive. It is the court that hears the first cry of the disfranchised, whether it is an illegal detention, the right to lead a dignified life, or a mandate to the administration. Article 226 ensures that the majesty of law is never more than a few miles away from the common man. It is this decentralized strength that maintains the federal balance of our republic. And it proves that while the Supreme Court may have the final word, the High Court often has the most vital one. It is in this backdrop that sometimes you might have seen that openly I shout very loudly, I am using the word shout, very loudly in court number 1, that why are you coming directly to the Supreme Court when you have an effective constitutional remedy of 226? And I had to sometimes observe that let us not give an impression that those who are affluent and those who can afford can have a privilege of enforcement of their perceived rights only through Article 32. Friends, if Article 226 is the armor of the citizen, then access to justice is the promise that this armor is available to all, not privileged or luxurious few. In our constitutional scheme, access is not merely the physical ability to enter a courtroom. It is the substantive assurance that when you do, the law will speak to your grievance with empathy and effectiveness. High courts, by their very design, are the primary architects of this democratization, while the Supreme Court remains the final citadel. Its geographical and procedural distance can often make it an intimidating sanctuary for the common man. It is here that the high courts perform their most transformative role, namely bridging the chasm between the letter of the law and the life of the citizen. One of the most profound ways Article 226 has enhanced access to justice is through the radical relaxation of locus standi. We moved from a traditional to the expensive concept of public interest litigation, where the locus standi became meaningless and this very condition was dismantled. As was eloquently highlighted, this was not just a procedural shift, it was a moral one. It allowed public-spirited individuals and organizations to knock on the doors of the high courts on behalf of those whose voices are muffled by poverty, illiteracy, or social marginalization. The power to take suo motu cognizance, though within well-known self-designed restraints, is another wonderful example how the tool of 226 can be effectively enforced to render true justice. Furthermore, the high courts have utilized Article 226 to fill what we call the legislative vacuum. When the law is silent, the sentinel does not remain mute. We have seen high courts issue temporary directions to protect the environment, ensure the dignity of prisoners, and secure the rights of migrant workers during national crisis. This is the principle of gap filling. The idea that the court's writ must run wherever there is a void in justice. Perhaps the most critical yet overlooked facet of access provided by Article 226 is the power of granting interim relief. For a small farmer whose land is being seized or a justice delayed is not justice denied, it is justice destroyed. The High Court's ability, therefore, to stay an executive action at the very first hearing is often the only real access the citizen ever experiences. It is the hallmark of the constitutional court's protective jurisdiction 226 to intervene at the threshold, ensuring status quo preserved so that justice is treated by the In this scenario, the High Courts fulfill the preambular promise of social, economic, and political justice. It ensures that the law is not a static monolith, but a dynamic force that bends the digital divide, the complexities of the sheer weight of mounting arrears, to justice to remain meaningful, the high courts, I would humbly say, must their powers but also evolve their practice. The first frontier is the digital gateway. In an era where a citizen's rights are likely to be infringed by an automated system or by burgeoning technology, our courts must adapt accordingly. Access to justice and the have-nots. Thus, technology must instead be harnessed towards ensuring justice equality. The judicial equality is a guarantee which the high courts need to enforce. How does this manifest in day-to-day courtroom functioning? Surely, it involves moving beyond viewing virtual hearing as an emergency measure and or a accessibility, reality, and affordable. Secondly, we must address the right remedy gap, and that should be done through procedural innovation. Fali often lamented the verbose nature of modern litigation. To truly improve access, our high courts could adopt a more streamlined adjudication process for clear-cut writ matters. We see the seeds of this in the notion of continuing mandamus, a judicial innovation where the court does not simply pass a one-time order but monitors the matter's progress over time. This is a practice I vividly recollect when I utilized during my tenure in Punjab and Haryana High Court while adjudicating on the issue of eradicating and creating a drug-free Punjab. Systems and structures address the issue in a long-term manner rather than seeking short-term solutions are often stunted. Judiciary ensures a catalyst for administrative change. Moreover, custodians of the law must guard against their own exhaustion. Access to justice is hollow if it comes ameliorating the role of the High Court requires a disciplined bar and a focused bench, both ensuring that the extraordinary jurisdiction of 226 in constitutional nature by routine disputes that have other adequate remedies. Finally, the future of the High Court depends on its ability to act as a proactive. The court must not only wait for the knock at its gate, but it also must remain alert to systemic failures in the rule of law. More to actions, the lives of the invisible victims of the justice delivery system, or the strengthening of the state and district authorities. The goal must be to transform access to justice from a passive right to state guaranteed service. At its heart, Article 2 serves as the lifeline of access to justice. It recognizes that justice cannot be reduced to a theoretical ideal confined to the pages of statutes or the corridors of courts. The High Courts function as dynamic The framers knew that the dignity of the individual, the framers knew that the dignity of the individual, once trampled through accessible covenant between the state and the people, one that transforms the bitter memory of colonial denial into a vibrant reality of constitutional governance. The interventions of the High Courts under 226 breathe life into the principle that the state is not about for ferreting out injustices in individual cases and passing remedial orders. Article 226 stands as the fulcrum upon which the scales of justice are balanced. It is a beacon illuminating the path toward justice in its truest and widest sense. That in India, liberty will never again be at the mercy of unchecked authority. For the High Courts remain ever vigilant, ever responsive, and ever the proud sentinels of our freedom. Dear friends, India's constitution is like a mighty river born from the confluence of hope, sacrifice, and vision. It begins as a pure spring in the mountains of freedom, weaving its way through valleys of challenges and plains of progress. In the early years, the river of our constitution as I was referring to, symbolizing the constitutional principles as a river. In the early years, the river of our constitution was still finding its course, cutting through the fresh soil of a young democracy. Fali entered the legal profession in that era, a bright and agile current joining the stream. His early advocacy mirrored the river's clarity, namely, firm principled and filled with the energy to carve new paths where none existed. As the river meandered through turbulent terrains, constitutional crisis, the emergency, questions of fundamental freedom, at that stage, Fali became the steady current that kept its flow true. He navigated the rapids of discord with courage, reminding the nation that even in stormy waters, the river must remain untamed by fear and unpolluted by compromise. Like a guiding current, he pulled the river back toward its rightful channel of liberty and constitutional morality. Our decades, now that we have over 7 decades, the river of our constitution has widened, deepened, and nourished the land of India. And Faliji's voice has flowed with it, sometimes as a swift rush in moments of urgency, and sometimes as a gentle stream of reasoned counsel. His arguments were the ripples that reminded us that law is alive, moving, and responsive to the banks that shape it. Today, as we behold the great river of Indian democracy, we see Faliji's reflection shimmering on its surface. His career is a testament to the idea that a river does not choose its journey, but It does choose how it flows, with clarity, with purpose, and with grace. He has been the current that guided our constitutional waters through storms and towards the vast ocean of justice. Fali Nariman's life teaches us that the Constitution, like a river, is not a static monument but a living force, one that requires vigilant stewards to keep its course true. In celebrating him, we celebrate the enduring flow of our constitutional journey. I am thankful to the organizers, to all of you, for inviting me, giving this opportunity to share my views, and giving this great opportunity to pay my compliments and tribute to the man ever known as one of the pillars of the Indian democracy and Indian constitutionalism, late Fali Nariman. Thank you very much. Jai Hind, Jai Bharat.